We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to this session of the Appeals Court that is being heard by Zoom conference. My name is Amy Blake, and I'm pleased to be joined today by Justice Peter Sachs and Justice Andy D'Angelo. We are your panel for the one case that we will be hearing today. The rules of the court are the same as if we were in person. That is, each person is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all of your papers, so you should get right to the issues. So with that, I will call our only case on the list, 2021 P0304, MARNA ORCUTT versus Paul ORCUTT. And counsel, just to remind you that this case is partially impounded. I assume that's as to the financial statements. So with that, Mr. Derland, when you're ready.
Sandy Derland, Schmidt and Federico here in Boston on behalf of the appellant Paul ORCUTT. Good morning, justices and Mr. Goodman. This divorce-related appeal, 18-year marriage with 3 very needy children, comes before you. And unless you have any questions, there are 3, I think, points on the Section 34 division that I'd like to address. I'm certainly aware that the climb to the top of a successful Section 34 appeal is a steep one. But in this case, I do think there are some problems which bear your intervention. First is the division itself using just the findings and the judgment terms themselves. The judge characterized this as a slightly disparate division, and I don't think that that is borne out by the judge's own findings.
Well, I'm going to stop you right there. If I use your numbers, I just want to make sure that I'm right. Her division using your numbers would result in a 57-43 for a delta of about 14%. And then if you use the tax withholdings, it becomes a 62-38. Is that your position?
It is.
So
that's precisely my position.
You know, I've done a few of these cases before, and we always, I think in hindsight, think, why did I use that particular word? But could slight not mean 60-40? Why is it 60-40? And I'm doing it, you know, picking that number just based on the percentages we just discussed. We know it can be disparate. We know it doesn't have to be equal. It has to be equitable. So why isn't a 60-40 split slight?
Well, I mean, I can't get into Judge Basinius's mind and determine what she may have meant. I think I think a reasonable interpretation of a slightly disparate isn't, in your example, Judge Blake, a 20% delta. I think it would be more of a 48-50-52 or something of that nature. And I don't want to split numerical hairs here, but I think when you take that approach, my approach, and you then look at the findings and the judgment as a whole, it isn't a slightly disparate division. It's grossly disparate, even without considering the taxes, as you pointed out, Judge, and then the other argument I have about the use of the retirement funds.
What if she hadn't said slight? She had just said a disparate division of assets. Any problem?
I think I would still have the same problem because certainly slightly as a qualifier, there's no question about that. And disparate is a broader term, but I think in this situation, again, reading it as a whole, reading the judgment, the rationale, and the findings as a whole, and then factoring in the contempt, which is sort of an ancillary issue, I don't see how a disparate division benefiting the wife in this case is fair and really makes sense, or to use the commonly thrown about term, adds up. I just don't think it does in this situation.
Speaking of adding up, I appreciated the chart on page 19 of your brief as an effort to capture the entire picture, but I had some problems with some of the math, and I don't want to go through it all, but one in particular. I'm not sure if you have it in front of you, but
I do.
The total allocation, which I took to mean the net assets of the estate, was 2.289. Mortgages totaling 839, and then net equity shown as 1.614. But when I subtract those numbers, I get 1.449, which is 164,000 difference. And I'm wondering whether I'm missing something.
You may be pointing out a sloppy calculation, Your Honor. But rather than go through the math here, Your Honor, I mean, the math speaks for itself. If an error was made, that's on me, and I regret that. And I certainly don't want to waste your time nor my time of trying to fix that. But I think from my perspective, nothing really changes, even if the percentages change, okay? So that sort of circles back to a point Justice Blake made, and that is whether it's slightly disparate or just disparate. I think in this situation, on whole, any benefit in the division, whatever the percentage, which would favor the wife, is unfair given the findings in this case. That's really the thrust of my argument.
So you think no matter what, it should have been 50-50?
Absolutely, or even favoring Mr. ORCUTT. And
so presumably you think she blew up the assets with what happened with the spot?
She absolutely did. And then when Judge Basinius faulted my client for using the retirement funds, and suggested that Ms. ORCUTT only benefited $35,000, I think that's also just belied by the evidence. And I don't know how you can even reach that conclusion when my client was effectively borrowing from Peter to pay Paul to keep this sinking ship afloat, to mix metaphors. I don't see how she didn't benefit across the board. And none of that was factored in.
Was she required to credit the husband's testimony and exhibits regarding how those withdrawals from the IRA were used?
Well, I mean, she's certainly not required to credit his testimony. There's no question about that. But even if she didn't believe his testimony, the bank statements and the Merrill Lynch statement showing the tax withholdings, those all speak for themselves. And the money was shown to be going from retirement to credit card, to checking accounts, and from checking accounts out. And the expenses, speak for themselves. They weren't creature comfort expenses. Judge Basinius suggested my client was continuing to lead the marital lifestyle. I just think that's belied by what was going on. And, these homes are being lost to foreclosure, being sold off to pay other debt off. I mean, their lifestyle was not being led. It just simply wasn't. And
what's your closest case, though, to this fact pattern, right? Because we have so many cases that affirm a disparate division, even in a longer term marriage. We do not parse the percentages. So I spent some time looking around, and what do you think your home run case is here?
You know what? That's a really good question, Judge Blake, because I don't know if I cited in that context in terms of my argument. The one that comes to mind is Denninger, where the division was
going old school.
Yeah, I know it's old school, but in that case, they did suggest the division was too stark to be sustained, or words to that effect. And I think I argued this the other way, and that is, the judge, I don't think, took into account or mischaracterized what was going on, and in effect punished him, which would be the Johnston case and other things like, and the Ross case, I don't know, I forget the case, where, their money was being spent on paramours and that sort of thing. So that's how I
Adams, I think appropriately, for the proposition that we would have to conclude that the division was, quote, plainly wrong and excessive.
Which it was in this case, without question, in my opinion. Again, when you look at what was really going on, what was happening on the ground here, My client was, liquidating, selling, and shifting money left and right to keep things running. And that's where all the money went. That
Counsel,
wasn't-
can I ask you about that?
Sure.
I understand your overall argument that the distribution was unfair. But can you point to specific findings that were made by the judge that you feel were clearly erroneous based on the evidence that the judge heard?
Excuse me. Well, the judge found without question that, and this is what I think she based the disparate division on. She found that my client, going back to the retirement, my client used the retirement to continue to lead the lifestyle. And Ms. ORCUTT only benefited $35,000. And again, I go through that in some detail in the brief, Justice D'Angelo, on page 23. Those expenses were not benefiting a lifestyle. Those were keeping things afloat: health insurance premiums, uninsured medical expenses, paying for Ms. ORCUTT's responsibility for the Florida condo, for the spa debt that she walked away from, paying household expenses. That's all not a creature or, the marital lifestyle, which they led when they had boats and cars and houses and vacations and so forth. That stopped. That stopped in 2014 when the divorce began, when the party's middle child started to suffer from serious health considerations, which impacted my client's ability to run a CPA practice. Ms. ORCUTT left for Florida and things just tanked. That's when this all went down. And that's where the judge, I think, was wrong. Clearly, my client used the retirement. There's no question about that. I mean, there's no question that can't be challenged, but how he used it, he was unduly punished. But, I can look at this another way. This case, really was a situation where everything landed on Mr. ORCUTT's shoulders, which was paying all the bills, maintaining all responsibility for debt, attending to all the children's day-to-day needs, which were substantial, even despite their ages. And then in the judgment, she benefits slightly disparately or favorably because he benefited from the use of the monies, which he had to benefit from because she wasn't meeting her responsibilities. I mean, it's a circular pattern that somehow he got blamed for. And I just think it's just unfair. And I know that, probate court judges have this tremendous discretion. And I understand that this is not an easy road to hoe, but I think in this situation, it's one of those strange scenarios where a Section 34 division really doesn't add up in this case. I really, and if I may segue to a lesser argument, but it's my last argument, and that is the child support. I mean,
in view of the time, could she have done what she did on the support, alimony, college, and uninsureds if she had made the finding that the statute requires? Could she have simply said, I am not ordering child support. I'm not ordering her to contribute to this, that, and the other. I'm not awarding alimony. And I find that this is in the best interest of the child and therefore deviate from the guidelines, period. Would that sentence or two sentences solve the issue here?
Well, I think on the surface, it would have been a better approach because she would have then met the deviation standards under the guidelines. But that said, again,
so even if she said that, you think she?
I still think. I mean, I really think
okay.
it's hard for me to reconcile this objectively. Even if the child support had been on a nominal basis, and I'm not even suggesting the minimum $25 a month or whatever. That's not really what I'm talking about. In this case, running the guidelines at the time would have been like $200 a week. It would not have been an onerous amount, but the findings suggest it's all on dad again, and she's contributing nothing for nothing. It's really hard to understand, and but if I may, it's just hard to justify. I'm sorry.
Does a judge have to go through the calculations, say, okay, here's what the presumptive guidelines child support would be. Here's what I would typically do with alimony. Here are the college and uninsured and other expenses. And looking at all these figures, I'm going to say it nets out and the best interest of the child are served by ordering nothing. Does the judge have to come up with the figures to do that?
Well, I think the guidelines do suggest that, you are to go through this 4-step approach to explain why you are not applying them presumptively or why you're deviating them.
But only as to child support, not alimony.
Right. But I also think the failure to do that does impact future modifications, the failure to make findings. And so I think in that respect, the finding was required. And, to the extent that Justice Blake is suggesting these are relatively simple findings that can be made sort of with the stroke of a pen, I understand that, but that would have helped. Certainly, that would have helped, I think, and it would help for future considerations of future modification. But that's not the bigger issue. The bigger issue is, again, how do you justify 0 child support in this situation? It's I don't know. I find it hard to believe. I really do. And I've been doing this a long time, for what that's worth.
And unless the panel has any other questions, seeing none, we're going to have to leave it there, Mr. Derlin. Mr.
Thank you.
Goodman.
Appreciate it.
I was muted. I am now, assuming you can hear me, I am ready.
I can.
I will wait for the blue screen though.
No,
Or
start
should I-
talking and it'll magically pop up.
Okay, great. I appreciate the opportunity to come before the panel today. I think it's important to note what the judgment actually says. And the judgment actually says, paragraph 4, mother shall pay no current child support to father. Paragraph 8, neither party shall pay any current alimony to the other. These are teed up very nicely by the trial court for a complaint for modification, as well as the very last finding, number 139, amongst the 21 pages of single-spaced findings and rationale. All 3 children may require post-secondary education or training to assist them in becoming self-supporting. So to the extent there were no tangible figures as to the children's potential, not apparent, but potential future needs, this is also teed up nicely for a potential complaint for modification.
How old were the children at the time of the divorce trial?
At the time of the divorce trial, I have their date of births. They were, none of them were emancipated. And Robert was, I'm just going to do the math, Your Honor, based on their.
Were they high school age or elementary school age?
They were high school age.
Okay, and we have lots of case law about you don't want to establish college expenses when they're elementary school age because we don't know what's going to happen. But when they're high school age, we have case law that says this is the appropriate time to look at that. So teeing it up is, you know, it's a little bit more than that, isn't it? It was on the horizon. It wasn't something that might happen down the road.
It was on the horizon, and the judge took it into account extensively in her findings. For example, finding of fact 120, number 120 discussed in detail the alimony term duration. And the judge found in the rationale very clearly that Mr. Orcutt's alimony obligation would terminate prior to the youngest child, Faith, becoming, the youngest child, Anne, becoming emancipated. Anne is the only.
You didn't appeal the alimony award, right?
We did not appeal
Okay.
the alimony award, Your Honor, but anything that gets remanded, if there is going to be a remand to the trial court, would necessarily need to include this combined support issue.
Well, let me ask you this. If I'm going to ask you the same question I asked Mr. Derlin. If Judge Basinius had said, I find that this would be the child support, this would be the alimony, but it's in the children's best interest to enter the judgment that she entered, would that foreclose the appellate issue that Mr. Derlin has raised?
Yes, it absolutely would.
So
As
should
well,
she have made that finding?
that would have been something that would be more helpful to, I believe, the litigants.
Well, it's not about helpful as much as it's a statutory requirement. So at a minimum, doesn't it have to go back for that analysis?
Not, Your Honor, if there was harmless error in the fact that the analysis was already made by the trial court. The court,
So what's your case that says that she's not required to make a statutory finding if it's harmless error? Do you have a case that supports that position?
Your Honor, I would direct the court's attention to the case of Calvin C. v. Amelia A., just based on the facts. There is an important requirement.
Well, Calvin C. talks about a snapshot in time. I don't think, I'm very familiar with Calvin C. I don't think Calvin C. addresses the issue of the lack of a statutory finding being harmless error. And correct me if I'm wrong, if you have a pin site for me to look at, I'm happy to do it. And if not, I will look at it after this hearing, but I really want to drill down on that issue because I don't see how her ultimate conclusion and decision as to the support amount might be right, but I don't see how we can't send it back within the absence of those statutory findings.
Statutory findings would be important. That would be something that would be much more helpful to the panel. And I understand, Judge Blake, you are looking for something more definitive in terms of what we would like to see in this. The rationale, spanning 4 pages, single spaced, talked extensively about what was best for the children, about the needs of the children, about the alimony.
So do you think we can infer the finding? Is that what you're saying?
Absolutely. And it doesn't take a very long leap to do so because of the extensive, and this brings me over to the section 34 factors, which are clearly delineated throughout the findings. One of which finding was the 179-day suspended sentence husband received. That's finding number 101 for breaking into mother's residence, wife's residence during the pendency of these proceedings. The retirement withdrawals are detailed, finding 106. It wasn't mentioned during my brother's presentation either about the 179-day suspended sentence for husband's contempt, nor the fact that he sold not 1, but 2 condominiums located in Norwood. That's finding number 48. And
I want to ask you about 2 things, well, actually 3 things in your brief. At page 40,
I'm there. Yes.
okay, the last sentence, the trial court assigned husband an obligation to pay alimony and then required him to pay absolutely nothing to the wife in deference to her child support obligation to him. Where did she assign him an obligation to pay alimony?
She did not assign him an obligation or her to pay any current alimony, but the trial judge considered alimony.
So I don't understand this sentence then.
The sentence, I think, is important because in her rationale, the trial judge determined that he would have an alimony obligation that would expire prior to the youngest child's emancipation. The trial judge went out of her way to set forth the alimony obligation that husband would have to wife based on his retirement age, how long that durational limit would go for. It was pinpointed to the number of months calculated on the divorce complaint service, 18 and a half years since the marriage, 1995, to the service of the complaint, 18 and a half years.
All right,
And
let's
based on father's age.
let's
He
move to
would have
page,
that obligation.
just be good, but I understand your point. It's not a dollar amount. You're just saying that the concept was there.
The concept was there extensively, yes.
Turn to page 44 and you say in the last paragraph, ultimately, husband is demanding that he be ordered to pay alimony retroactive to the date of the judgment of divorce so he can receive a smaller measure child support from the wife. Where is that coming from?
Finding 83 specifically incorporated, it didn't become part of the judgment, but the temporary order calculation as to the weekly amount of $222 per week net under the snapshot that was used and remained in effect throughout these very long proceedings. Husband had an obligation to pay wife $222.
Where in the judgment is he demanding he be ordered to pay retroactive alimony? I mean, we know under Holmes that temporary orders aren't used in the calculation for duration of alimony, so I don't understand this sentence.
Husband would like the trial court.
But would like is different than is demanding. I would like a lot of things too, but there's a difference between wanting something and demanding something.
Well, I think husband's brief makes it clear that he's requesting that the trial court enter an order of child support in his favor, which would necessitate the spousal support calculation to be made by the trial court. And the trial court could very well determine the net amount is zero. That's what the trial court did in this instance. And every portion of that was considered.
So I think this goes to an overall concern that I have about your brief, which is there's certainly a lot of good discussion and law, but and I represented clients, and I know how difficult it is to represent clients in a contested divorce. But your brief contains ad hominem attacks on the husband. You discuss things outside of the appellate record. You use values of things that you got offline on the day before your brief was filed. And I have to say, normally I wouldn't say anything about that, but you claim that husband's appeal is frivolous and you're asking for double fees and costs. And when I look at your brief, respectfully, you didn't follow the rules about appellate brief writing. So you've got to convince me that the husband has a frivolous appeal here in the backdrop of what I've just said about your brief.
It was determined, finding number 75, and the court went out of its way, the trial court went out of its way to note the husband has a history of being financially dishonest. And with respect to my brother's arguments, page 19 and page 20 of his brief, there's values assigned on this document that husband developed, whereas the Spywood Road property, wife doesn't receive any of those assets until 2025. With respect to Clubhouse in 55 Clubhouse in New Hampshire and 344 Wanaki Road in New Hampshire, the calculations as to wife assets receiving half of the equity, those properties were already sold and compiled, assembled by the trial court with the knowledge that they were already sold by husband after the divorce trial was completed, but before the divorce judgment issued. He went ahead despite the restraining order on assets, not only with the Norwood condominium, but also with both properties in New Hampshire, without even seeking court approval, let alone telling the
So
wife.
how does that make his appeal frivolous? If I agree with everything you've just said, right, we're looking at whether or not the judge abused her discretion in what she says is a slightly disparate division of assets. And I don't know what slight means in this context. We certainly know it wasn't equal. I don't know if it was equitable. I need to think about that, but I'm struggling with some of the contentions about husband's appeal, but I guess we should move on in light of the time. And let me ask you that, what does a slightly disparate division mean? And what is your best case?
Justice Blake, a slight disparate, a slight disparate division of the marital estate to me means certainly more than 50%. And the explanation given by the trial judge was that husband continued to live the lifestyle enjoyed during the marriage. And how? How did he do that? By liquidating the retirement accounts selling the Norwood condominiums to the tune of nearly, just on the retirement alone, $500,000 to his good. And by
Counsel,
selling,
Counsel, I'd like to ask you about that because opposing counsel raised that issue, that finding in essence was not really supported by the record. And I know the judge made that conclusion that those things were sold to support his, I'm not quite remembering the word she used, but in essence, a high style life. Whereas counsel for the husband says that was used to support the children and maintain. What in the record, actual record, was there to support the judge's finding that it was really to maintain his high style of life?
in the record, I can point the court to the appendix, and this is page 132. It's actually at the top, it's marked as page 130. He testified that he was still attending.
Which volume? I'm sorry, which volume of the appendix?
7,
Thank you,
Justice Blake.
thank you.
And he proceeds to testify right around what is bait stamped 132 for 5 pages, all the different gentlemen clubs he continued to frequent. And he continued to frequent those gentlemen clubs, and he would also take trips to South Dakota, etc., these biker conventions. That is part of the brief. That's supported by the record. And when he sold the Norwood condominium, the HUD settlement statement is part, or the CD is part of the record as well. And he kept $150,000. But it's more than that. He didn't seek court approval to do it. He didn't even notify the wife or pay her one dime. That came out at trial, and the trial court correctly provided the wife with what the trial court used as their own adjective, a slight, disparate allocation division of the marital estate. But it's supported by all of the findings, absolutely. And
Let me check. I see your time is up. Let me check with Justice Sachs and Justice D'Angelo if they have any additional questions. I don't see any. 15 minutes goes fast, gentlemen. We very much appreciate your briefs and your argument. The case will be deemed under advisement. Thank you both. And this concludes not only this hearing, but this session of the